Ready, start. Under Section 25 of the Evidence Act, a confession made to a police officer by a person accused of an offence shall not be proved against him. Full stop. Power to record confessions is given to a judicial magistrate. Full stop. Strict and rigorous guidelines have been laid down to record such judicial confessions under Section 164 CRPC. Full stop. Such safeguards are founded on the well settled principle that confession is an admission of guilt. Full stop. Ordinarily, nobody would like to admit his guilt as he is fully aware that the same would be used against him. Full stop. That apart, an accused has a constitutional and fundamental right against testimonial compulsion. Full stop. Therefore, Section 15 of the TADA Act completely altered the fundamental rules of evidence. Full stop. Wires of the TADA Act was challenged before the Supreme Court in Kartar Singh Supra full stop. A constitution bench of this court, while upholding the validity of Section 15 of the TADA Act as well as the entirety of the Act, however, laid down certain guidelines so as to ensure that confession obtained in the pre-indictment interrogation by a police officer not lower in rank than a superintendent of police is not tainted with any vice but is in strict compliance with well recognized and accepted aesthetic principles and fundamental fairness. Full stop. This court further clarified that though it is entirely for the court trying the offence to decide the question of admissibility or reliability of a confession, in its judicial wisdom strictly adhering to the law, it must satisfy itself that there was no trap, no track, and no importune seeking of evidence during the phase of custodial interrogation. Full stop. The court should also satisfy itself that all the required conditions are fulfilled. Full stop. This court further emphasized that in order to ensure a higher level of scrutiny vis-a-vis applicability of TADA Act, there should be a screening committee or a review committee both at the central level as well as at the state level. Full stop. In the case of SN Dubey Supra a two-judge bench of this court negated the contention of the defense that a confession under Section 15 of the TADA Act should be recorded in two phases, that is, the preliminary part containing the record of how and for what purpose the person was forwarded and the questions and answers put to him for ascertaining his voluntary willingness to make a confession even after being told that the confession may be used against him as a piece of evidence, and the second part which contains the actual confessional statement. Full stop. Contention of the defense was that it is the second part which has to be regarded as the actual confessional statement and not the preliminary part. Full stop. Therefore, the obligation to explain and ascertain is to be performed while recording the real confessional part. Full stop. Such explanation and ascertainment done earlier when the preliminary part was recorded cannot be regarded as proper compliance with the requirement of Rule 15 2 full stop. The police officer must explain and give the statutory warning before the actual confessional part starts, and it is at that point of time that he has to ascertain by questioning the person making it that he is making the confession voluntarily. Full stop. Therefore, the contention that when the confession is recorded in two parts, only the second part can be regarded as the confession, and while recording the second part, the police officer should give the statutory warning and then ascertain if the person concerned is making it voluntarily, cannot be accepted, full stop. The requirement of law is that before recording the confession, the police officer should ascertain by putting questions to the maker of it that he is making the confession voluntarily, and he should also explain to him that he is not bound to make the confession and that if he makes it that can be used against him as evidence, full stop. In this case, DSP Sindhe had put questions to each of the accused who was brought before him to ascertain if he was willing to make a confession voluntarily, and had also given the statutory warning to him on that day. Full stop. Even after the accused had shown his willingness to make a confession, Sindhe had given him time not exceeding 48 hours to think over his readiness to make the confession. Full stop. When the accused was brought to him again, he had again ascertained if he was still ready and willing to give a statement. Full stop. He had also asked him if he was making it under any pressure or coercion or threat. Full stop. Only after the accused had replied in the negative, he had told the accused to say whatever he wanted to state about Suresh Dubey's murder. Full stop.